and he's given until the Friday of that week. A bit tight, but you know the president is not just sitting there waiting for us, so we had to give him a reasonable amount of time, and he was given until the Friday. On the Friday, he responded to the letter of demand, and on the Monday, the papers were finished. I think they were served on the Tuesday, the 12th. So literally, there's not even a day in between all those steps. So that's clearly treating the matter with the urgency that it deserves. Now, let's come to the second leg of the point. I can't say collective view now, because it's the other parties will say whatever they have to say. But at least for the applicant's point of view is that the agency has in any event been overtaken by events. So what actually happened, again, just to take this court, because of course we have to take this court into the part where it was not part of the matter. What happened is that the matter was set down on the 26th of August in the urgent court, in the normal urgent court, quote unquote. And the acting judge president took it upon himself to say that this matter, because of the size of the papers and all that, is not suitable for the urgent court, and he would give it to a special allocation. So if you go to 036-7. Oh yes, let me try. That's correct. Yeah. Yes, thank you, Justice Tomei. I'll check it. I'm not capable of those things. Exactly. But one of my juniors will direct the court. It's 036-7. The presiding judge is there. Are the other justices found? Maybe I'll ask anyone else who is able to direct. Are you able? I don't know. No, not you, madam. I've stopped the clock by then. No. Okay, my juniors are okay. To save time, I'll just read it out, but we'll work out the auto-direct in due course. Yeah, thank you. It's a short passage here. Okay, it says under the item Justice Venlopai 1, 2, 3, 4 from the bottom, 25 August 2025. Yes. So this is a joint chronology of the parties, so that again it shows that everyone understood what was happening. It says the acting judge president informs the parties that the matter is not suitable for the urgent court and will not be heard on 26 August, and that the matter will be case managed. So it's a clear cut that that's what happened. That's common cause. And why did the acting judge president do that? As I say, at least the one reason that he gave us in our case management meeting was the fact that the papers are bulky, but I'm sure there were many other reasons. So what does that mean? That means the issue of urgency is really not on the cards, because the matter would not have been allocated to 3 judges on a special allocation as a special motion. He would have just said, go to urgent court, and then in urgent court on the 26th, whatever, we would have had an argument about he could not have possibly allocated 3 charges to deal with urgency. that would have been a waste of judicial resources when there's already an urgent court sitting. So that's the second leg of the thing. So the first leg is the chronology to show that the matter was A, in the court it was regarded as urgent, B, it was brought urgently in relation to the August events because we had to give the president time, and C, the urgency is in any event overtaken by events as said by the acting judge president. D, which is the last point, is this. Forget everything I've said. The matter on its own legs is self-evidently urgent because the three events. But remember the principle in 20th Century Fox, which is one of the cases we refer to in our heads. Again, to save time, I'll just. No, let me give that reference just in case. You'll find that at page 027-6, which is page -6, Justice, which is paragraph 12 of our heads. And again, I'll read it for the benefit of the bench. It says, however, before the full court, the technical objection based on urgency has clearly been overtaken by events, hence the special allocation to the full court. That's the point I just made. In the unlikely event, we say, that any party will unreasonably still wish to dispute the self-evident urgency of this application, then submissions will be made based on the papers and the principles laid out in the leading cases of 1. Apleni, 2. Secretary of State Capture Commission versus Zuma, and 3. 20th Century Fox. So let me start with 20th Century Fox. 20th Century Fox, the principle laid there, my ladies, is that when you are dealing with urgency, you have to assume, like any other preliminary point, by the way, whether it's jurisdiction or agency or whatever, you have to assume that the facts that are pleaded are true. In other words, that's how you deal with jurisdiction, that's how you deal with agency, that's how you deal with anything. You have to assume that the facts are true for the purposes of agency. Obviously, when you get to the main case, that assumption falls away. So that's a crucial principle of our law. So now let's come to this matter. If you have to assume that everything we have said here is true, then how can the matter not be urgent? If you assume that our entire criminal justice system is in the hands of criminal syndicates, if you assume that the allegations made in the founding affidavit that the entire, and you know, this criminal justice system is a nice sounding phrase, but actually what it means is that criminal syndicates who are living in a mafia state, in other words, criminal syndicates are in charge of the police, the prosecution, and the judiciary. Now, if you have to assume that, as someone put it yesterday, the criminal justice system is on the brink of collapse. So if the criminal justice system itself is on the brink of collapse, it means the whole country is on the brink of collapse. Because, I mean, what will be left? So that's the first issue. The second issue is that the president himself says, and you'll find this in bundle B, I think it's MKU2. Bundle B, my ladies, is shucks. Yeah, MK2. You'll find that at page that's the 152 015-42. No, that's the wrong reference. sorry, my lady. For some reason, it's not here. But it's the... I'll paraphrase. The President, when he made his announcement on the 13th of July, said, again, I don't think anyone can contest that, said these matters require urgent attention and urgent investigation and so on. The word urgent appears, I don't know how many times in that. And even in his affidavit, answering affidavit, he says, again, I don't think I need to convince the court about that these matters threaten the very security of the state, and therefore they need urgent attention. That's why he, even on that day, as you were saying that thing, he had already appointed a commission. He had already done this and that within the space of less than a week. So there's no question from anybody's mind if the President himself says that, who is now the opponent here. As I say, Minister Mchunu, to his credit, did not even raise the issue in the other, because the matter is obviously urgent in the Constitutional Court. Okay, so yeah, in MK2, the President says these allegations therefore call for an urgent and comprehensive investigation. And as I said, you'll find that running right through the affidavit, because everyone knows that the matter is urgent. Last point is that okay, so if you have to assume using Century Fox that what we are saying is true. So there's a commission which started yesterday that is inconsistent with the Constitution. 2, there is I don't know whether acting minister or whatever, that's another debate we'll have later, who's illegally appointed. So actually the whole country is now being run illegally, the security system. And 3, you assume that there's another minister, also called the Minister of Police, who's on leave, being paid by the taxpayer for the next, at least minimum of 6 months, for doing nothing. Just assume those 3 things only. And on what basis can one say, no, you can hear this in due course? What is due course? Due course means February, March next year, when the whole commission will be done. 300 million or whatever of taxpayers' money later. Then the court then can say, oh no, 6 months ago this was illegal. What would be the sense of that? Yeah. So, with the greatest respect, my ladies, this is a matter that, honestly, for all those reasons, is each one of those reasons alone: the Concord, the AJP's actions, the merits of the case, the Century Fox, and the fact that we're dealing with unprecedented events. Again, I don't have to convince the court about that. That's what was said in the case of Secretary for State Capture Commission versus Zuma. The Concord said, we are hearing this matter on an urgent basis, direct access on a criminal matter, so to speak, which has never happened. Why? Because they said it's because this is unprecedented territory. And Apleni, this court held in Apleni that, 1, if you have the following 3 things, the matter is urgent. 1, there's a contest about the rule of law. 2, there's wastage of state state resources. The citation is at the bottom of page 8. Just trying to find Apleni. Anyway, this court is familiar with Apleni. There's allegations of abuse of state power. All of those things are present in this case 10 times, if you like. In Apleni, it was just a minister. Here we're dealing with a president. In a plane, it was just the suspension of a DG. Here we're dealing with all the three things that I've mentioned, which are monumentally. And in a plane, there was suggestion of abuse of process. We've said, yeah, there's abuse of process because Minister Mchunu, the relationship between Minister Mchunu and the President, which again, for the purposes of urgency, you must assume to be true, is that the reason he did this whole hullabaloo is to save his friend or political ally or whatever from the obvious action, which should be the dismissal. And that is why he acted inconsistently. For example, if you compare what he did with the DA Deputy Minister, Whitfield, whose only sin was that he just went overseas, compared to how he treats someone who's said to be working with drug cartels and all that. That alone, again, you must assume that is true. So it means all those cases, Apleni, Zuma case, and 20th century are applicable. And this court is bound by, well, it's not bound in the sense that it's one judge, but at least it will have to say it was wrong, what Fabricius J. said in Apleni, when he said, if you have abuse of court process, and you are fighting about human rights or rule of law, there's allegations of abuse of the public purse, then it's urgent. That's what this court said in a plane, and that was correct. Just checking if how much time I have. Yes. My little friend is foregoing her time, but she's asked me to do something. Just to refer the court to 02-22. Yes. Yes, that that's where we make the Apleni point in the founding affidavit. So that point was even made in the founding affidavit. We don't just make it in the heads. So we say the matter falls squarely within the test articulated by this court in Apleni, in that one, it involves the multiple violations of human rights of the applicants, their supporters, and the public at large. That's the allegation. Two, that there are serious allegations of bias, improper motive, abuse of state power, and part of the President. And three, that there are serious allegations of the unnecessary waste of taxpayers' money and public resources. So the point is made squarely in the founding affidavit itself on that point. So all in all, for all the 5, 6, or whatever number of reasons, standing alone, let alone cumulatively considered, the matter is, the president or a reasonable president of any country should want to know as soon as possible whether he's wasting 150 million, 300 million of money, whether his appointment of a minister is legal or illegal, or whether his placement of someone on special leave is legal or illegal. Surely. But forget the president. 60 million people also want to know this, because it's their money that would be otherwise be wasted. So they want to know it's legal or it's illegal. There are only two options. If it's legal, fine, then it will go carry on. If it's illegal, then it must be stopped at the earliest possible time, because that's our money. It might be small money to other people, but 150 million, which is the minimum budget, is a lot of money. And since my learned friend has given me, let me make this point, because it's very important. One of the allegations that is made in the merits is that the minister, Mr. Madonsela's client, interfered and took 121 dockets from the political killings team away from investigation to be stored in Gauteng for some strange reason. Now, just that alone, it's easy to sit here air-conditioned rooms and just look at it like that. But if you are one, if you are one of, well, maybe the air conditioning might not be working. Thank you, Justice Tolmei. Well, it's supposed to be an air-conditioned room. Yeah. It's easy to do that on a serious note. But just think, let's just pause and be human for a minute. Imagine that one of those dockets, of those people who were killed in the political killing stars team, is your brother, your mother, your aunt, and that person was killed. 121 dead bodies minimum. Maybe some of the dockets have more than one dead person. No. Well, but I've just explained how 20th Century Fox says you must get to the merits. You must actually assume that they are true. So how else? If 20th Century Fox says you, for the purposes of agency, you have to assume that the merits are true. So there's no escaping the merits. Yeah. So the agency is only in relation to the merits. Now the point I'm making is that if you were one of those victims of somebody who was killed, and the police, through crime syndicates, took your docket away, and that investigation is not happening, and we come here and we say, oh, that's not urgent. You must just deal with it. We'll see you next year. That is what we're dealing with in this particular case, apart from the fact that the whole country would like to know what is happening. But there's a human factor for mothers, aunts, uncles, and one of the TV stations did a great job by going to those families and speaking to them in the last 2 weeks and humanizing this whole thing, because we just think 121 dockets and so on. No, these are human beings like you and me, and they are mad that dockets have been stolen or taken by drug lords. And we say, no, it's not urgent. They must just, I don't know. Anyway, those are the submissions for the... Okay.
Just to clarify something.
So, okay, yes. I'll prioritize the bench.
Before my sisters come in their questions, just to clarify the process here.
Yes.
In all matters that are filed as urgent applications, once the pages are more than 500,
yes,
the matters are referred to the DJP.
Yes.
For special allocation.
Yes.
The only difference with this case is that he allocated 3 judges.
Yes.
But that doesn't mean that when he does that, it means that the judges or the judge who's going to hear those matters doesn't have to deal with agency.
No,
I just wanted to clarify that.
Absolutely. No. No, that's definitely not our submission. I mean, if it was our submission, we would be saying, what are you asking? No. The court is entitled to raise this. Our learned friends are entitled to raise it as well. There's nobody says just because a matter, simply because a matter is special allocation. I mean, we've done that. I've done that 100 times in this court, of referring matters to the DJP, and then it's brought here. In fact, one of the biggest matters which we are going to refer to in the merits had to do with another commission. We came here, and the matter was specially allocated to, I think it was the judge president himself. That was the matter about the State Capture Commission. And the parties we still argued agency. I was the first one to raise it. No, that's not our in fact, yes, no, we're clear. In fact, I can even refer your ladyship specifically to the same thing that happened last week in the Sibia matter. The Sibia matter was specially allocated by yourself, acting DJP, to the full court, and the judgment came about 2 days ago, or whenever, a few days ago. And in paragraph 4 of that judgment, Davis J. here refers to that history. He says the matter was referred to the ADJP, it was referred here, and therefore agency was no longer an issue. He says it in the matter. So I'm quite clear on how the process works. The point we're making is that it was clear. In fact, I might say this from the bar if my learned friends don't object. The ADJP wanted to allocate this matter for last week. We were not, me and one of my juniors were not available because I was in another court. And then he said, okay, we'll do the week after. Normally courts don't sit this week because it's the last week of term. But he said, I'll make an exception because the matter is self-evidently urgent. It needs to be heard, and that is why he did it like that. That's this, yeah. Right.
So I just want to understand, I think everyone in this country agrees that the situation is urgent.
Yes.
Does that render this specific application urgent?
Yeah. Okay, yes, I understand the question, Justice told me. Yes, you can't divorce the situation from this matter, because this matter is about bringing the situation to be adjudicated by a court of law. So what the situation is, which is that we need to know as a matter of urgency from a court of law. That is why the matter was brought as a matter of urgency to the apex court in the first place, because it needs to be, we need to know, as I say, Justice Tolmay, at the moment it's 50-50. It's either legal or illegal. But that's the very question that the country needs to know as soon as possible. Because otherwise, if we know that answer to that question in March or April next year, we might as well not know it. Because by then we'll have spent hundreds of millions of rand. We might as the so-called special leave would have proceeded unabated, with drivers, air travel, free this and free that, free housing, free accommodation, and then next year you say, no, you should not have had those privileges at the taxpayer's expense. What would be the point of that? So that's my answer, short answer, Justice told me, is that the two things are inextricably and symbiotically intertwined.
If we can get back to the Constitutional Court, you would agree with me that in order for the Constitutional Court to come to any conclusion, the first thing that they have to decide is whether they have exclusive jurisdiction and whether direct access should be allowed. So it seems to me quite evident that they did not decide the question of urgency.
Yes. Thank you, Justice Tolmay. No, we're together. They did not decide the question of urgency because nobody raised it. Because everyone assumed that the matter was urgent. So it works like this, as you know, Justice Tolmay. If I come here for a matter that should have been in Durban, and I say I'm raising jurisdiction, your question, if you are sitting in the urgent court, Mr. Mpofu, assume everything you say is correct. But why are you in the urgent court? Because this thing happened 100 years ago. So urgency is the primary question. So if the Constitutional Court was of the view that the matter was not urgent, it would not have dealt with jurisdiction or direct access.
Aren't we speculating? Because
no.
As far as I understand it, and please correct me if I'm wrong,
yes,
they didn't give reasons. We are still waiting for the reasons.
Yeah, correct.
So all we know is what the order says, and the order says the direct
exclusive jurisdiction,
and
direct access,
and the application for direct access was refused.
Yes.
So this court will have to decide on its own whether this application is urgent. There's nothing to deter this court from deciding that.
No. Again, as I was saying to the presiding judge, there's nothing to deter this court. Please, if anyone is understanding me to be saying this court is deterred from dealing with this question, please, then it means it's my fault. I'm not saying that. All I'm saying is that you are right, Justice Tolmay. We don't know the reasons. But what we know is the law. All of us here, we know that in law, if the question of urgency was decided against us, they would not have been able, as a matter of law, to reach jurisdiction or to reach direct access. That's just the law. It doesn't matter what the reasons are and so on. If that court had said, Okay, Mr. Mpofu, before we all these interesting things, but why do you wake us up on a Sunday and we have to be here? And they find that there's no urgency. That would have been the end of it. There would have been no need to debate issues of direct access or jurisdiction. As a matter of law, urgency, as it is happening here now, is the primary, is the foremost, is the first question. So you can deduct, any lawyer can deduct that, well, if we dealt with the merits or we dealt with the preliminary points, therefore it means urgency either was decided against, if it had been taken, it was decided against them, but in this case it was not even taken. So it was assumed to exist. That's the only point I'm making. So you have to accept as a matter of law that the Constitutional Court dealt with the matter as a matter of urgency. Hence they gave judgment within 24 hours. Because the matter was self-evidently urgent. Hence they gave us those directions on a Sunday and so on. Those are the only points I'm making. Thank you, Justice Chair. But it never precluded, it didn't say, if any party, I mean, an example is the second respondent. They didn't, they considered urgency there, but here they took it. We couldn't say to them, oh no, you can't take it now. It's their right.
Okay, Mr. Mpofu, in your submissions, you said that this matter was referred to this court by the Constitutional Court. Did I hear you correctly?
Yes. No, that's why I did this. What I was saying, that's why I did this. I was saying, when the Constitutional Court, Justice Malopa says that, when it says, okay, forget about exclusive jurisdiction for a minute. Let's just talk about direct access. When it says we don't have direct access in this matter, what it is saying in English is that this matter should go to the High Court first before it comes back to us in terms of Section 172(2)(a). And that's why people even found it strange that the Constitutional Court said costs are reserved. And I had to debate it with my learned friends. What does it mean costs are reserved? So because the matter will come back to the Constitutional Court in terms of 172(2)(a). So what they are saying in shorthand is that it must first go to the High Court, and so that we get the wisdom of that court and so on. Rightly or wrongly, we think wrongly, but that's neither here nor there. Similarly, when it says we don't have exclusive jurisdiction, it means the courts have jurisdiction, the High Court has jurisdiction, but not us. So that's why I did this, Justice, to say, therefore, what they were saying is that we can't hear it because we are the apex court. We can't hear it. In fact, the full sentence is, when we talk about direct access, we cannot hear this matter as a court of first instance. That's really what they're saying. Yeah. We'll hear it as a matter of second or third instance or whatever. And something related to that, Justice Maloba, is the fact that the matter has, if you like, I can't remember the paragraph now, but we say in our founding affidavit, this matter has got two legs. The first leg is the July events, the second leg is the August events. So that, obviously, the Concord could not have spoken about the August events because they had not happened. It was July. But as far as that is concerned, that's why I broke it down to say, as far as the July events, this was the Concord. But after that, I then gave you the blow by blow. This is what happened on the 1st, this is what happened on the 4th, this is what happened in relation to the second leg, which is the August events. Because the August events were kick-started by the so-called, the new introduction of a new thing in this whole case called Minister Without Portfolio, which was an attempt to retrofit the facts, as it were, because it was obvious that it was illegal, the appointment of Minister Kachelia or Acting Minister Kachelia. And that's why the August events then kickstart almost a new process, which is why we asked the 15 questions and asked for reasons. And the President did not even have the courtesy of giving us reasons, which is a duty of accountability. There's no President who cannot give you reasons. even if whatever. To say to a citizen who says, why did you do this and this and this and this, 15 questions, and please give us your reasons, and then you give them the middle finger. Say, I'm not going to tell you. This, well, not this court, the SCA said in the case of Johannesburg Bar versus JSC, if you do that, you are basically denying the litigant the right to go to court and ask for rationality. Because how are you going to ask for rationality when you don't know what the reasons were? And for a president to do that is really something that this court will argue later should honestly frown upon. Even if this matter was not of this magnitude, even if it was about the dog license, you can't say, I'm not going to give you reasons when you are a public, you are accountable to the public.
I think you went into the merits at that point. I was about to just say, just to interrupt you and say to you that, Mr. Mpofu, I think now we're going into the merits. And if we could go back to the issue of the urgency. But at least you have stopped your submissions, so it's fine.
Yes, okay. I have to say this again. Yeah. It is not possible, well, in my limited experience, it is not possible to decide the question of urgency divorced from the merits. I mean, if I say I'm here because my father is sitting in a hospital, he's about to die, and some doctor is going to pull the plug, and therefore I'm here, court. I don't even have papers. I'm just here because in the next 2 hours, my father is going to be, the plug is going to, you can't say, no, don't tell us about what's happening in the hospital. We just want to hear you an urgency. Urgency of what? It's the urgency of the fact that there is a life-threatening situation. The only difference here is that the life-threatening situation is for the country itself, not one father. All of us, 60 million of us, are on life support because the criminal justice system has been hijacked by the mafia. So it's a difference between urgency in relation to one person who's about to die and a nation that is on the brink of collapse.
Thank you, Mr. Mpofu. I think we'll now hear the first respondents. Counsel, Mr. Maynard.
Sorry.
Thank you, Justices. Just to clarify the first point, that agency was squarely raised by the first respondent in this court. And you will find that in the answering affidavit is addressed from page 007-10. I'll come back to that. That's the first point. And it was never abandoned. When the matter was case managed by the AJP, the first respondent made it clear that it persisted in the issue of agency and in fact opposed the request that the matter be allocated for 2 days and insisted that it should proceed in the urgent court so that that issue can be addressed. And the court will find the letter in the 030-22. It's attached to that, to the interlocutory application for the admission of further evidence. So that was made clear by the first respondent, and our understanding from the AJP, both in relation to the question of agency and the interlocutory application, was that this court will determine those matters because the court is already seized with the matter. That's the first point. In this court, agency has been squarely raised, has been addressed also in the heads of argument of the first respondent quite comprehensively at 032-10, fully addressing all of the points raised by the first applicant, the applicants. The second point is about the Constitutional Court, and is to clarify matters there. The question of agency in the Constitutional Court was argued by the first respondent as part of the direct access application. In other words, that agency is relevant to direct access. That was raised. Now, the fact that the court declined direct access and exclusive jurisdiction, in fact counts against the first applicant then for it, because if it insisted that the matter was urgent and justified direct access and the court said no direct access, you can come to the High Court. In fact, the conclusion on urgency, if there is any, we're speculating because we don't have reasons, would squarely be against the applicants and not for them. But what the Constitutional Court certainly did was to decline jurisdiction and did not decide any other issue. So this court, as it were, is at large to determine whether the matter is urgent, applying the test for urgency. And we know in terms of Rule 612 that it is this court's discretion to determine whether this matter justifies jumping the queue and being addressed at the point at which sought to be addressed, given even the weighty issues that the matter raises about the executive powers and the like. There are two core requirements for urgency which we address in our heads of argument. The first is that you have to satisfy the court that you cannot obtain substantial redress in due course. And you have to not only just make a bare allegation, you have to say why that is the case. That's the first one. And secondly, you should show that you have come to court as quickly as you could, approach the court for relief. And we'll demonstrate that on their own founding affidavit, they fail both tests, specifically fail the no substantial relief in due course. And that matter of agency in the applicant's founding affidavit is dealt with at 002-20. You will see, my ladies, that when you read that 3 pages dealing with agency, nothing is said about substantial redress in due course. Nothing. Absolutely zilch. What it says at 55, paragraph 55 is, it will be observed that no opposing party contested the self-evident agency of this matter in the answering papers in the Constitutional Court. This was understandable and sensible in the circumstances. Accordingly, it is not reasonably anticipated that agency will be an issue. Nevertheless, we address it. They had to. They are seeking urgent audience with this court, and they couldn't simply prejudge how the respondents were going to respond. And then they say 56, as explained above, the agency of the matter is clearly not self-created, and it can never reasonably be asserted that relief may be obtained in due course. That's all they say about relief in due course. They don't say why that is the case. They say only that the commission has already commenced at taxpayers' money. Well, that means the horse has bolted. That doesn't make the matter urgent, it makes the matter less urgent, because you will get relief under Section 172B in due course of the Constitution. When the court, if the court declares the commission unlawful, it will give just an equitable remedy. This court will do the same. This court may decline to set aside the Commission of Inquiry, even if my learned friends were to convince the court that there is an invalidity about that commission. So their position now and their position later is no different. And the second point they say is that the so-called Minister of Police has since assumed office. So the horse has bolted. The minister is in his office, he's performing his function. That is not a justification for agency. It counts against them. They should have come to court to stop the minister taking office. They tried, but they went to the wrong court. Who's to blame for that? They say the minister who has been illegally placed on special leave is on special leave. Yes. So the horse has bolted on 3 decisions that they contest. And then they say there are unprecedented allegations of executive and judicial capture in 62. That's the situation versus the agency of this case. The situation is being addressed agency by the Commission of Inquiry and the appointment of a new minister who is looking after the police to ensure that there is no interference in the investigations. They say in 63 it involves the inherently urgent matter of the protection of whistleblowers who risks all of the public benefit, usually as a last resort, as in this case. This court can do nothing about protecting whistleblowers, even if it finds for the applicants. It's not the relief they seek in their application. So there is no case made out why a Section 172 relief in due course would not be sufficient if the matter was heard in due course, because commissions of inquiries, outcomes of commissions of inquiries are routinely reviewed and set aside by courts, and appropriate relief can be granted in that regard. And there is nothing special about this particular commission of inquiry than other commissions of inquiry that have been allowed to run their course. And whoever is aggrieved by those outcomes come to court. Then at 64 they tell you that, recall that in the chronology, their application in the Constitutional Court was dismissed on the 31st of July. What did they do when that application was dismissed? They wrote a letter to the President, and that, my ladies will find at 002-58. That's the letter Marlene Trent says, with lots of interrogatories, that's what I'll call them, interrogatories. It's not a letter simply saying, give us your reasons for the decisions you've made. It's an interrogation. And there is a response, and the President did not simply show them the middle finger. You will find the response at 00267. So you will see that that letter is dated 4 August. So they waited from the 31st of July after their application was dismissed until the 4th of August to write the letter. And all they have done coming to this court is to repackage their application that they had sent to the Constitutional Court and even attach the Constitutional Court application. There's no reason why instead of coming to court they wrote a letter. They wrote a letter on the 4th of August, and we're happy to wait for the President's response on the 8th of August, which the court will find at 002-67. And the President's response is headed 31 July announcement and 1 August conduct. The Presidency has received your letter dated 4 August in which you demand answers to a number of questions and threaten urgent court proceedings. I have been asked to respond to your letter on the President's instructions. Your letter indicates that it is written on the instructions of your client, former President Zuma, who is the leader of the Mkhwanazi party. The information that your client seeks in paragraph 3 of the letter is for the most part already in the public domain and was dealt with in the President's answering affidavit in the proceedings before the Constitutional Court. Reasons were given for all of the decisions that they are challenging. 4. To the extent that your client seeks information that is not already available to him, he will be aware as the leader of the Mkhwanazi party of the procedure under Chapter 10 of the National Assembly Rules to address a request for oral or written questions to the President. That is the appropriate manner for a political party and its leader to address questions to the President. When the President receives questions through those proper procedures, he deals with them in accordance with the requirements of the rules. 5. In any event, it is unclear on what basis the questions are being asked, because in paragraph 4 of your letter, you make it clear that irrespective of any answers that the President may give to the questions, your client has already concluded that his conduct was unlawful. So they didn't need the answers to come to this court. Furthermore, the President shall not comply with the demands in paragraph 5 of your letter. He stands by the reasons for his decisions as recorded in his answering affidavit in the proceedings before the Constitutional Court. The decisions were lawful, rational, and consistent with the President's constitutional duties. Finally, there is no basis for urgent court proceedings to be instituted at this stage. In the event that your client nonetheless proceeds to do so, any such application will be opposed at that very stage. And then the application was only launched, I think, on the 12th of August. So from the 31st of July, when the Constitutional Court application was dismissed, they waited to the 12th of August to launch the self-same application, just properly adapted for this court. So we submit that both on substantial redress in due course and on approaching a court as quickly as you can, they fail. Then they rely on the Applicant judgment. They say, well, the Applicant judgment says you can allege abuse of state resources, you can allege breach of rights, and that's enough. Three factors, they say, that's enough to justify agency. But reliance on Applicant is really unhelpful for the applicant, and we deal with that at 032-16. That in Applicant, the court held that the matter was inherently urgent because it involved multiple violations of human rights of the applicants, their supporters and the public at large. There are serious allegations of bias, improper motives and abuse of state power on the part of the President, and there are serious allegations of the unnecessary waste of taxpayers' money and public resources. The applicant's case in Apleni was partly predicated on a contention that there were essential functions at the department that demanded specialized expertise and institutional memory, and that could not adequately be discharged by an acting DG. So the DG must be restored. He also alleged that substantial government projects at the department faced delays and impediments due to the institutional instability precipitated by his suspension, and that the minister exceeded her authority and deliberately sought to remove him as the DG. He thus argued that the immediate setting aside of his suspension was imperative. That's in paragraph 24, we summarize the facts here are different. Here there's questions about whether the President had the power to place a minister on suspension and the power to appoint an acting minister, or what they call a minister without portfolio, and they don't understand what that is. Or and in relation to the Commission of Inquiry, is not a question of that the President didn't have the powers. It is that it was an irrational exercise of the powers. So you don't have a basis, as in Apleni, that the institutional memory is required and expertise is required. Otherwise, the functions of the department are not able to be carried out, and there is institutional instability. They merely want to rely on rights, the breach of rights, and what they call abuse of power, but that's merely exercising a power one doesn't have. It's not an abuse, it's just you acted ultra vires. And the cases that have decided that the mere breach of constitutional rights on its own is not justification for agency are referred to in our heads at 032-18 and at footnote 34 and 35. 34 is Hots and others versus University of Cape Town at paragraph 15, and Moyani versus Ramaphosa and others at paragraph 33. All of those make it clear that there is no inherent agency just because you've alleged a breach of rights. So that covers the question of agency, and I referred the court to where we deal with it in the answering affidavit, because the answering affidavit deals with it fully and also deals with the correspondence that I read to the court. And we would submit that in the discretion of the court, this is a matter which ought not to take the court's time in the agent role, on the agent role, because this is allocated on an agent basis where this court must decide whether there's agency. The applicants have failed to meet the requirements for agency, and the court can refuse to hear the matter by either striking it off the roll or dismissing it, and the parties can roll it for hearing in due course.
Thank you.
Just to add something on yes. Just to complete the point about substantial redress in due course, the court will be familiar with the case of Nhlanhla, where the Constitutional Court ultimately ordered repayments of salaries that were unlawfully paid. It just demonstrating the wide discretion which a court has when it hears a constitutional challenge and has to decide what an appropriate remedy would be in a particular set of circumstances. Those remedies are available for the applicants today, and they are available for the applicants in a year's time. They don't go away. And so there is no basis to justify agency on the ground that there will be no substantial redress in due course.
Thank you.
Those are submissions. Thank you.
We hear the Council President respondent. Mr. Madlanga.
Yes, Madam Mr. Mandate has taken the steam out of my argument with reference to the fact that there is a redress in due course with reference to the case in Hassan. I will not address that issue anymore until he has already done. confine myself to 3 issues, which are foreshadowed in our answering affidavit at folder 17, page 17, and the answering affidavit, pages 22 to 36.
Not us. The country wants you to start.
Oh, okay, yeah. No, my documents, all my documents are there. So if I don't have a closer reach to my documents, I will be assisted. So the arguments about agency on behalf of the second respondent are foreshadowed in folder 17, pages 10 to page 14, paragraph 22 to 36 of the answering affidavit. It is correct, and under the rubric of agency, we would like to address 4 issues which have been raised. The first issue, which we raise in the answering affidavit, is that agency in this court has dissipated from the agency that once was in the Constitutional Court. And we make the point in paragraph 32 of our answering affidavit that was so because of the applicant's adoption of a bad legal strategy when they approached the Constitutional Court for direct access in circumstances where their claim to direct access and exclusive jurisdiction was precarious. And the point we make, my lady, is that it was open to them when approaching the Constitutional Court to approach litigation in belt and braces, to approach the Constitutional Court conditionally on the basis that they would approach this court and only access jurisdiction of the court or direct access to the court if this court does not exercise or does not hear the matter, or vice versa, to approach the Constitutional Court on the basis that they will tell this court, if they had approached this court, that the matter has been seized or has been accepted by the Constitutional Court. They adopted a bad legal strategy in not adopting that approach, because if they had done so, then the outcome that ultimately came from the Constitutional Court, where the Constitutional Court declined jurisdiction, would have left available the remedy of them coming to this court at that time. You recall, my lady, the reason why they approached the Constitutional Court and the agency was claimed at that time was in anticipation of the Madlanga Commission, which was due to start on the 1st of September. 1st of August, I'm told. No, it was 1st of September, my lady. That was the anticipation. And the Constitutional Court created a regime for the entertainment of the matter up until, as it were, 31 of July. I think my little friend is correct when he says 1st of August. But then there was a postponement, which is irrelevant, which is now being sought to be introduced by interlocutory application. But the point of it is that the anticipation and the agents of the matter arose from the fact that there was a Madlanga Commission which was due to start around the corner. And also, the agency arose because Kachala's appointment was due to take place on a day, like the 1st of August. So the matter remained agent in the Constitutional Court, and we did not take agency at that point for that reason. But once the Constitutional Court declined to exercise jurisdiction, the agency that there was dissipated. And I'll deal with this with reference to the chronology, and that's the second part of my argument. The chronology of the matter indicates that the decisions which are impugned in this case were taken on the 13th of July. And you'll see this in the chronology in folder 14. Sorry, it's folder 36, page 3. And the judgment or the decision itself is in MK2 in bundle B at folder 15. The next timeline that is important is the 18th of July, where the applicants approached the Constitutional Court And you'll see that in the chronology at page 5, sorry. It's the folder 36. And we know that in the Constitutional Court, the President took the point on jurisdiction and direct access when it filed its answering affidavit on the 23rd of July. So it must have been clear to them, at least as early as 23 July, that their jurisdiction and access or direct access to the Constitutional Court was precarious. Even at that point, it was open to them to approach this court and say, look, the President has taken jurisdiction and direct access. In case we fail, want to preserve our agency and come to this court. They didn't do so. The next timeline is 3rd July, when the Court heard the matter, and 31 July, when it delivered its order, declining to exercise jurisdiction and not to hear the matter. We know from that date that the applicants waited for 12 days thereafter, knowing that the matter is urgent, and far away from the time that Nhlanhla was supposed to take office, or rather when the Madlanga Commission was supposed to take place. But we know that, the timeline is that on the 1st of August, I think Professor Nhlanhla took office. On the 1st of August. But Madlanga Commission was due to start a month later on the 1st of September. It didn't start for one or other reasons, but that was the anticipation, one of the anticipated events. So at least by the 12th of August, the urgency of this matter had dissipated, firstly because by that time, Nhlanhla had already been appointed. 2, the date for the hearing of the Madlanga Commission had been identified, which was the 1st of September. But knowing all those events were upcoming, the applicants waited for 12 days from 31 July and only launched this application on the 12th of August. And in the process, constrained the respondents to deliver answering affidavit in severely truncated timelines. I think the first and second respondents were given 2 or 3 days to deliver an answering affidavit on a case that had, as Malal Fen says, repackaged. It was not, and we submit it is not open to this court to allow the applicants to do this and to trample without explanation why such truncated timelines should be observed and imposed on the respondents to answer this case. The result is that something was done by the respondents to try and meet with the timelines and the facts which needed to be placed on record, as it now turns out with reference to the interlocutor application, had not been placed on record. So it is unfair for the respondents to have been placed in this impossible position to answer a big case like this in severely truncated timelines without an explanation why this matter should be dealt with on an urgent basis. So, my ladies, you are right when you say this case must be decided first and foremost on whether it is urgent or not, given the circumstances which have come before now when the matter was litigated. Not only before now, when the matter was litigated in this court, but also how the matter was litigated in the Constitutional Court. Urgency raises its ugly head in this case. More so because the respondents have not been placed in a proper position to deal with the matter comprehensively. Now, thirdly, and I don't want to deal with this point, it's the point of absence of allegations or traversal of the requirement of this court that the applicant who comes to this court must at the very least demonstrate that he will not be afforded substantial redress in due course. Not even a sentence is dedicated to that. But we know, as Manfred has said, that there is substantial redress in due course. Because if this application is pursued on rule of law grounds to vindicate the rule of law, which is an incident of constitutional principle of legality and constitutionalism. If that is the point, under the rule of law remedies, there are a number of remedies available to the applicant now and later, which will accord substantial vindication of the rights of the applicants and the citizens of this country. In due course, in the applicant's application, there is no engagement, not even an attempt to engage with these requirements. With the result that this court is entitled in our submission to return a verdict that it does not have to deal with this matter on an urgent basis. Finally, we have heard today from my learned friend that reliance is made to the 121 dockets which have were removed from the political task teams by the minister as a basis for agency. And he says that's the abuse of court. That you will not find in the founding affidavit. That's the unfairness of this agency, to now try and run the argument on agency on the basis of an argument that was never raised in the founding affidavit. The point about this 121 dockets argument, which has been raised for the first time in support of agency in this court, is now submission nothing else but to sensationalize the matter in order to elude and avoid a legal issue of agency. The dockets, the 121 dockets, are a subject of discussion in the Madlanga Commission now. And that's the point. Why the President referred the matter to the Madlanga Commission, to have those matters play themselves out and dealt with in the Madlanga Commission. And that's where they belong. And the country today is hearing evidence on that part, at least on the part of Mkhwanazi. There's so much furore around it until Mr. Mkhwanazi, or Lieutenant General Mkhwanazi, is cross-examined. But that is where the issue of the 121 docket belongs. It cannot be and should never be and was never made a basis of agency in this court. So we submit, my ladies, that the point of agency has been well taken, and this court should decline to entertain the matter urgently. We can wait for a day, another day, when rule of law arguments which are raised in this case can be raised properly. When all the information, including the information that the applicant wants to introduce to this court by way of an interlocutor application, has been properly ventilated, including the ventilation of the issues, the very issues that Manfred relies on for agency, have properly been ventilated before Madlanga Commission. This is not the time, not the occasion, when this matter should be heard on the matter of agency. So on those submissions, we say the matter is not urgent and agency has been well taken. I'm getting used to not being asked questions.
Yes, I'll be quick, my lady. My learned friend is anyway. Let me just deal with this firstly, just the factual misrepresentations, so that we get that out of the way. My learned friend, Mr. Maineche, really fudges a very simple issue by clever lawyering. So he says that the issue of urgency was raised in the Concord. Well, that's simply not true. You must just look at the answering affidavits in the Constitutional Court, both of them. Look for the word urgency. You won't find it. Because Mr. Madonsela, as he correctly points out, conceded urgency openly. And Mr. Maineche simply failed to raise it. That's it. So the reality is this. It doesn't work the way he's trying. It's actually a very creative argument. So he's saying, because one of the factors when you deal with direct access is the importance of the matter and its urgency and so on. So somewhere there was hidden. When they said there's no direct access, they meant also that there's no urgency. But that argument doesn't work if you think about it. Because what he has forgotten is that direct access is all in the Constitutional Court is always argued in the alternative. So you start by saying this court has exclusive jurisdiction. But if I'm wrong, then direct access. So the court would not have reached the exclusive jurisdiction if what my learned friend is saying, forget about direct access. Let's assume we didn't even ask for direct access. The court there would not have even reached the exclusive jurisdiction if it thought the matter was not urgent. So his argument falls flat, creative as it was intended to be. Then he says, which is not true, and my learned friend knows this. He says the reasons that we asked for in our letter of the 4th of August I'm going to quote him verbatim, reasons were given for all the challenges. That can't be true, logically. How could the president on the 20-something of July had given us reasons about what was going to happen on the 1st, about the minister without portfolio, the swearing in, the change of titles, and all the things we complain about? How could he, unless if the president is a sangoma, that we knew that on the 1st of August there'll be all these other things that are happening? It's impossible. That's why we were asking the questions, because we're saying, this is now what has happened, tell us A, B, C, D, or whatever. So that's just simply false. My learned friend also says, let me then deal with my nature very systematically, having disposed of the misrepresentation. Now, this court, probably this very court, no, I think it was 6E. I was standing here on a matter of this, as I indicated to the presiding judge, where the parties were saying, no, the matter is not urgent. And that was in relation to the State Capture Commission issue. And they were saying all these things that my learned friends are saying. No, they can get it in due course. The report can be, it doesn't matter whether it's next year or whatever. But this court said no. This is a matter of the utmost national importance. It has to be heard urgently. It has to be heard by 3 judges, and it must be heard now. And it was indeed so. And let me say this, there can be different rules when it's one president and other rules when it's another president. I was in that matter acting against the former president, who is my client today. And this court agreed that the matter of that setting up of the commission was a matter of urgency. But listen to this. This court went further. for the first time, and I argued that standing here upstairs, this court imposed punitive cost orders for the first time against the president on the basis that it was self-evident that the matter is urgent for the country, and yet he incidentally were taking the same point that we're taking now, or rather they were taking the same point we're taking now, of the conflict of interest in relation to whether, in this case we're saying whether Justice Madlanga can sit as a judge who's also part of the accused institutions. In that case it was whether the president can appoint that commission when his son and himself and so on. So the issues were the same.
Was that matter brought in the urgent court?
Yes, it was charged for I know exactly. In the normal urgent court. Yes. In fact, it was not even urgent. I remember Justice told me it was what you call super urgent. I slept for 1 hour that day. We did the papers the whole night and drove here, and Judge Fourie was sitting in the urgent court. And Judge Fourie said, well, this matter I'm going to refer to the DJP then, I think, or AJP, or JP, I'm not sure. As a result, to cut a long story short, Justice told me, as a result, Judge Fourie was one of the 3 judges. So once the allocation was done, it was then chaired by or presided over by the JP, and then it was Judge Fourie. I can't remember the 3rd judge. I think it was Judge Barachowicz was the 3rd one. So it was exactly this situation, and the special allocation, and as I was explaining to the presiding judge, that didn't mean they abandoned urgency, neither did it mean the court must not hear it. So we argued it, but the court, I'm saying, the court went further and imposed punitive costs against that president because what president can say a matter of this magnitude? What president really? What president can do that? Say the matter of this magnitude must not be clarified as a matter of urgency. I don't think there is such a person. Because that thing we were dealing with there about some rondavels that were built in a rural area, compared to what we're dealing with here, is just chalk and cheese. So that's as far as Mr. Mainecha is concerned. I'll deal with his overlapping things with Mr. Madonsela. Yes, most of the points are overlapping with Mr. Madonsela. But the last point I want to make, which covers both of them, as far as Mr. Mainecha is concerned, is that Mr. Mainecha agrees that Justice Fabricius in Apleni ruled that if those 3 requirements, I won't repeat them, are met, then the matter is inherently urgent. Now, there are not many matters in our courts which are regarded as inherently urgent. There are 2 that I know of. One is, there's a case called Victoria Ratepayers something in the Eastern Cape, which was decided about contempt of court. And the court there, I forget the name of the judge now, the court there said, well, a matter of contempt of court is inherently urgent. The other matter which our courts have decided as inherently urgent is this kind of matter, where there are those 3 requirements: rule of law, human rights, public purse, and sorry. Yes. So it was not all these things Mr. Manager is telling you about the DG had to go and do this and the other. That's irrelevant. This is all that Justice Fabricius said. I hold that. Sorry. Before he says that, it says, where allegations are made, allegations, right, which goes back to this question about the merits. The allegations are obviously made in the merits. Where allegations are made relating to abuse of power, present in this case many times, because we're saying he was just doing it because of his close political alliance, and that's why this one was treated differently to Mr. Whitfield.
Sorry,
Paragraph.
Can you just direct us to the page number?
Yes, I'm sorry, Justice. I'll ask my learned friend. I think they uploaded that case.
Yes, I think there are plenty cases uploaded. I just need to be able to follow.
It's in the joint bundle as well, I'm told. I'll refer to you, Justice Mokos. I'll refer the pages. Can I quickly just read it? It's a short sentence.
Okay.
I will refer. I think it's paragraph.
This one has been directed to that case.
Paragraph 10. Has it been directed? Yes, paragraph 10, Justice Mokos. Yes, thank you very much. Yeah. I apologize. Yeah. He says, yeah, yeah, bottom of paragraph 12, it's 040-1132. Where allegations are made relating to abuse of power by a minister, not even a president, or other public official, obviously, which may impact upon the rule of law, tick, and may have a detrimental impact on the public purse, tick, the relevant relief sought ought normally be urgently considered. So, whether those three are met, that's all he said. He didn't say all these things that my learned friend was saying. And the question is whether, if those, and I'm saying here, those things are met 100-fold, if you like. All those three things. So this court, unless if it's going to find that a plane was wrongly decided, has to follow that very good example, which has been followed countrywide, if I may say. This whole issue was argued in a case I was in Mthatha a month ago. The Apleni test, always, once it applies, the agency is inherently present. So that's as far as Mr. Mkhwanazi is concerned. And maybe the last word on Mr. Mkhwanazi. Mr. Mkhwanazi says that in this court, and he's correct, in this court they opposed agency. Very true. But that's exactly the point we've been making, that this is a malafide attempt to avoid the bad merits of this case. That's all it is. And if this court falls for that, where this party is simply dogged in its determination to avoid the merits of this case. And again, with the greatest respect, a president who does that should not be rewarded with another technicality as they did in the Constitutional Court. So having now gotten away with technical arguments in the Constitutional Court, they now had to, because now the issue of jurisdiction was obvious, so they had to find another branch to hold on. You know, as when someone is sinking, you just hold on to anything. So they then had to hold on to agency. It's true, Mr. Mkhwanazi is saying, they opposed the special allocation, the DJP still did it. They opposed the matter being referred to the full court, the DJP still did it. They opposed the matter being set down for 2 days, it was still done. They opposed exclusive jurisdiction in the court. They opposed direct access. They opposed the interlocutory application that's brought here. Why? Because there is no justification for the major illegalities that the president has committed. There isn't. So their job is simply to make sure that the merits of this case are never heard. And we just carry on and on and on a matter that's self-evidently urgent. And that alone, the malafides in that strategy, from a president know-how, is really something that no court should countenance. Because why? What are they scared of? Why don't we should be now right in the middle of the merits and determine once and for all whether there were illegalities or no illegalities. You don't have to be putting tires and stones on the road and every little thing to avoid the case. There are 3 judges, they've read the papers, the matter has been allocated. Let's get on with it and get an answer one way or the other, and then if the matter might go back to the Constitutional Court or not or whatever. Remember that even if we succeed, the matter still has to go to the Constitutional Court for confirmation. So that alone is a matter of urgency. It's a matter of law. There's nothing we can do. If you say we agree with everything you say, Mr. Mbofu, I still have to go to the Constitutional Court. And that will take another 2 months or a month or whatever if the Constitutional Court considers it urgent, which I'm sure it will. So when will the matter ever be heard? Anyway, if the court allows them now for the 7th time to avoid the matter, that's fine. Now, as far as Mr. Madlanga is concerned, really, I'm embarrassed, to say the least. Mr. Madlanga says here that it was a bad legal strategy to go to the Constitutional Court seeking exclusive jurisdiction and direct access. Well, Mr. Madlanga and his client, Mr. Mchunu, considered direct access and exclusive jurisdiction in the Constitutional Court. So they thought it was a good legal strategy. They considered it. They considered agency. Now today, opportunistically, he says it should not have been done. Well, that's really, I don't know what to say about that. But to Mr. Madlanga's credit, he then says, the matter remained urgent in the Court. So at least he concedes, he doesn't withdraw his concession, let me put it that way. So he concedes that the matter was urgent until the end of July. But according to him, and I'll show you why that is wrong, after that, it was no longer urgent. But how can that be? Because after that, from the 1st of August, I've told the court in detail what happened. And that on its own is urgent. Forget about Concord and whatever. Let's just assume everything started on the 1st of August. And there was somebody called Minister Without Portfolio who says, I'm an acting minister, and the president, no, he's a minister, and then the media says he's an acting. Nobody knows in this country what to call that person. He doesn't even know himself. At the Interpol, he was called acting minister. He was sitting behind the thing that says acting minister. A week later, he says, no, I'm the minister. I'm not, and so on. No, we all don't know. If you ask anybody in this room, you'll get 3 different answers. Someone will say acting minister, minister without portfolio, or whatever. Why would a president not want that to be clarified by a court of law, once and for all? Anyway, the next point that Mr. Madlanga comes with, I have never, and I'm not blaming Mr. Madlanga for this, it's probably my ignorance, but I've never heard of this procedure that he has concocted here. That you go to the Constitutional Court and do exclusive jurisdiction and direct access, but you apply here as well, just in case. Where has that ever happened? That's only done in terms of when you do a direct appeal. When you do a direct appeal, then you do a direct appeal because you don't want to miss the 15 days here, then you do a conditional application. But in my entire life, I've never heard of someone going for exclusive jurisdiction and direct access, but have a plan B in some high court. As I say, yeah, maybe it's me. Then Mr. Madlanga says that he actually says this, and again, this time I must give credit to Mr. Manager, because at least he was fair. Maybe let me put it that way. Mr. Manager read to you all the sentences where we talk about the why the matter cannot be heard in due course. We explain, it's 002-20 onwards. Mr. Madlanga says there's not even one sentence on this. Well, there's about 10 sentences here. The first sentence is paragraph 56, 02-20. As explained above, the urgency of the matter is clearly not self-created, and it can never be reasonably asserted that the relief may be obtained in due course. That's the first sentence. And then we explain from 57 onwards why. We say the commission has already commenced. All the things, I don't have to repeat that. I said that in chief. 2, we say the president has breached his oath of office to be faithful to the Republic of South Africa and to promote the rights of all South Africans. 3, we say the so-called Minister of Police has since assumed office and will be making decisions which affect the security of the people of South Africa. The appointment is in breach of 91, 96, and 98 of the Constitution. 4, we say the Minister of Police who has been illegally placed, quote unquote, there's no such thing as placing someone on leave of absence. That's why we put those brackets. Placed on leave of absence by the President continues to earn a salary and enjoy other expensive privileges such as bodyguards, drivers, free ministerial accommodation, air travel, domestic workers, and the like. As we speak, as we're standing here, that is happening. 5, we say it is fact that the matter involves very serious and unprecedented allegations. That's the Zuma case thing which I said earlier. It is impossible to imagine a greater catastrophe than which would transpire if these allegations are true. And the matter is not heard as one of the utmost urgency. In relation to the question of urgency, the merits must be regarded as true and proven. That's the point I made earlier, 20th century. And then 6, we say it involves an inherently urgent matter and the protection of whistleblowers who risk it all for public benefit, usually as a last resort, as in this case. We all know, at least I can say this, I'm sure my learned friends won't object, that General Mkhwanazi says he tried everything until he had to call that press conference. He went to Parliament, he went to this as a whistleblower. And we say this is not just a normal whistleblower, by the way. This is a police general, something forgotten. This is a police general, and the most forgotten thing, which is in the president's address, is that these are not, he didn't just wake up and make these allegations. He says these are allegations which were made after an investigation by the police task team. So it's exactly the same situation as the public protector matter I'm talking about in 2017, because Public Protector Madlanga then had done an investigation and then was coming to this court. So similarly, Justice Mkhwanazi, General Mkhwanazi says we did an investigation. A senior general in the police says we've done an investigation and we find that we live in a mafia state. So that's the reality. And then 7, we then say that we've spoken to the HAP, number 8, Aplani, and so on. I don't have to go through that. So for Mr. Madlanga, I'd say not a single sentence has been said. It's just palpably false. Therefore, all in all, 3 broad points. 1, the matter is, we are all here now, prepared to argue the matter. Full heads have been given. The list of authorities have been given. 3 judges who have read the papers, and the matter must finally go ahead. 2, the manner, and I say this carefully, deliberately, the manner in which the matter has been case managed by the Judge President to this point, and the manner in which it was treated by the Constitutional Court. I won't put it higher than that. The manner in which it was treated by the Constitutional Court and the manner that it was case managed here all indicate that it is commensurate, let me put it that way, with the obvious urgency of the matter. 3, the requirements of inherent urgency, which are in Apleni, have all been met, exceedingly so, more than in Apleni. And 4, the interest of the public and the victims of those political killings would like to know, and so would the rest of the 60 million citizens of this country, whether the criminal justice system, starting from the police to the NPA, to the security services, to the metro services, to the judiciary, and the metro in 3 countries, is in the hands of drug lords. That if that is not urgent, then nothing ever will be. Nothing under the sun. Well, if that, the resolution of those issues is not urgent, then we must just close the urgent court in South Africa, because nothing, anything else will just be, if somebody wants to evict me and so on, so what, compared to what we're dealing with here? Then we must just say Rule 612 is banished. There's no such thing as urgency. Because I can't, I mean, I'm being serious here. I'd like anybody, I'm inviting anybody who's listening to this to imagine something that could be more urgent than what we're dealing with here. Just try to imagine it. What, nuclear war, or I don't know. But there's nothing that can be more urgent than the resolution of these issues. If there are, it's hard to imagine. I'm sure there are 1 or 2 things that could be worse, but they are very hard to imagine. But one thing I can tell you before I sit down is that any of the things that are regarded as urgent in all the 9 provinces on a weekly basis cannot compare to what we're dealing with here. Anything. I'm prepared to put money on. You can bring any example of matters that are considered to be urgent and say compare that to the capture of the police, the capture of the NPA, and the capture of the judiciary. Just compare that if assume for a minute it's true, because for now we have to assume it's true. Forget about what Judge Zondo was dealing with. That was nothing. Compared to what we're dealing with here, the capture of 1 person or 3 or 4, whatever, compared to the capture of the judiciary. I mean, honestly, I can't even imagine that myself, what it would mean. If someone says, I can understand if they say the metropolis are corrupt. Well, I'm sure everyone thinks that. Or if you say the police are corrupt, well, dockets disappear and all sorts of things. The NPA starts to be serious. If you say the NPA is captured, well, it's serious. But the judiciary and the magistracy, and that's what the president's own terms of reference say. The Madlanga Commission must investigate any member of the judiciary or the magistrate. Any member, everyone. Any. Justice Ines CJ, as long ago as 1926, said the word any means unlimited. If I say any car, I mean all the cars in the country. If I say any member of the judiciary, I mean all the members of the judiciary in the country. And that's the president, not me, who says that. In terms of reference number 4, says any member of the judiciary could be in the hands of the pockets of the mafia. We'll play YouTube. Give them the middle finger. But forget.
What is it?
Yes. YouTube. They did not just give them the middle finger, but forget. Yes, exactly. But assume he didn't say it. I don't want to be bogged down with side issues. But the point of the matter is that the president gave us the middle finger. Because, as I've said, there is no public official who does not have a duty. Let me find the case of. It was Justice Brandt, J.A., paragraph 44 of the case of Cape Bar Council, I think versus the JSC. I'll get the citation now. Please. I'm sorry, I have to. Sorry, Justices. I apologize. No. What is? 040-425. Sorry. Yes, please. 425, Justices, yes. You'll remember the facts of this case very briefly was that the JSC, and I hope it was before I was sitting in that body. Yeah, it was 2013. The JSC said, we do interviews for judges, there are sensitive matters and so on. We don't have a duty to give reasons because we have deliberations in camera and what have you and so on and so on. And this is what Judge Brandt said at paragraph 43. I cannot see how the inference of an obligation to give reasons can be avoided. It is difficult, listen to this, it is difficult to think of a way to account for one's decision other than to give reasons. As to rationality, he says, I think it is rather cynical to say to an affected individual, quote, you have a constitutional right to a rational decision, but you are not entitled to know the reasons for that decision. How will the individual ever be able to rebut the defense by the decision maker when he says, quote, trust me, I have a good reason, but I'm not prepared to provide them. Exemption from giving reasons will therefore almost invariably result in immunity from any rationality challenge. And then he goes on to say, I believe these same sentiments were expressed by Justice Mkhwanazi in Nhlanhla.
The merits of the case. I just want to be urgency now. Your pertinent points regarding that, the rationality at this stage of the decision is not something that we're going to decide at this point.
Justice told me, I'm busy doing a reply. And so in the reply, I'm only have to deal with what my learned friends have raised. Mr. Mkhwanazi said to you that he read a full letter and nobody said he's now going into the merits. He read the letter. So I'm replying to that.
We're dealing just with, my critique at this stage is limited to the question of rationality or not.
No.
I heard what he said and I'm hearing what you say. But whether it's rational or not will not be determined at this point.
Yeah, no, you're right. No, I'm not dealing with rationality, Justice Tolme. I'm dealing with the failure to give reasons, not rationality. The fact that Justice Brandt dealt with it is neither here nor there. I'm busy responding. If Mr. Manetjes was correct in reading that letter, then I'm entitled to respond to it in reply. I mean, that's the least.
Obviously, you
Yes, thank you. So I must not read.
Reference to what we are dealing with now. Just the urgency, but continue.
All right, okay. All right. Well, I'll leave Mr. Manetjes' point.
No, you don't have to leave the point.
Okay.
And continue with the point.
Thank you.
But just limited to what we're dealing with now, which is the urgency.
Okay, well, I'm limiting it to whatever Mr. Manetjes was reading that letter for.
Yes.
Okay. So I'm saying that for Mr. Manetjes to say to you, justices, firstly, wrongly I've said earlier that the reasons were given even for the things that had not happened is false. But secondly, I'm saying in the letter he read to you, you did not hear a single reason being given. Because the reasons were the failure or refusal to give reasons then falls squarely in this passage that I've just read. That's really all I'm saying. Where the SCA, which is binding on this court, said it is difficult to think of a way to account for one's decision other than to give reasons. That's all. I'm not saying anything more than that. And in response to Mr. Manetjes. So if that submission is not allowable, well then Mr. Manetjes' reading of that letter must be struck off.
We did allow you to address.
Yes, yeah. Thank you. No, thank you, Justices. I think maybe I must just wrap up to say that this matter is inherently urgent on the basis of our planning and on the basis of its public importance. I actually feel embarrassed to even have to explain to the court how grave this matter is. I don't think there's any South African alive who doesn't understand how grave the issues we're dealing with are. And even gravity is an understatement. But I have to make that submission. And if, as Mr. Madlanga says, it was, at least he says it was urgent until the end of July, and now all these other things that happened on the 1st of August. And our learned friends cannot with a straight face say, this happened on the 1st of August, and we waited until the 12th of August. Waited for what? On the following day, working day, we wrote a letter to the President and gave him 4 days to respond. He responded on the Friday. We gave them the papers the following Tuesday. Waiting means lying supine and doing nothing. No. A letter with 15 questions was sent to the President on the next working day. And he was given 4 days to respond. And when he didn't, when he gave us the middle finger, the application was brought. And we know that one of the reasons why he owed us those reasons is that, as we all know, the reasons might have been good. He might have given very good reasons. And then we say, okay, we're not going to court. The President has now answered the questions and is clear. We now know whether the man is a minister without portfolio or an acting minister and so on. Then why would we be here? We came here exactly because the President gave us the middle finger on the 8th of August and failed, as Justice Brandt to say, to carry the most basic duty of any public official to give reasons to a citizen who's asking for those reasons. That's the only reason we're here. If the President had on that Friday had said, here are my reasons, here are my 12 reasons or whatever, we wouldn't be standing here in front of you. We would have, or at least we could have not been standing here. We could have said, okay, well, this is convincing enough. We got it all wrong. We didn't understand what the President was really doing is this and the other. And then they say, we set. Yes, okay, well, it's a quick point. That the letter that we're talking about of the 4th, by the way, was sent on behalf of my client, former President Zuma. It was from KMNS attorneys. And this was all in an effort to avoid coming to court, if you like. The MK party did not get involved in that. What they wanted was merely to continue with the matter that was in the Constitutional Court. And what the MK party did was to write to the Chief Justice and say, we don't agree with your ruling on direct access. We don't agree with your ruling on exclusive jurisdiction. Please give us the reasons urgently. And you've got the answer, it's somewhere there. They said, no, we're busy. The reasons will come when they come. And we're still waiting, there's nothing we can do. Because that could have also avoided us coming here. If we had those reasons, we could have said, well, we don't even have to come to the High Court. We go to back to the Court for reconsideration or whatever, depending on those reasons. But we can't do that. Our hands are tied because we don't have the reasons, as Justice Tolmay pointed out. As we're sitting here, we don't have the reasons. So the only sensible thing to do, if we had waited for those reasons and then come here 2 months later, this court would justifiably say, go away. You couldn't have just waited for those reasons. You should have come as soon as you can here, which is what we did.
Anything else?
Those are our submissions.
So the second applicant is also covered?
Yes, I think so.
Indeed, my lady, I am covered.
Yes, she is. So the reply is composite.
Thank you. I see, Mr. Manager.
Yes, with the leave of the court, I just ask the leave of the court to correct one error. That's probably an error of communication.
Yes.
When I took the court to the letter in which the President responded to the list of questions, I did not intend to convey that the concession that the President showed the applicants a middle finger. What I meant to convey is he did not show them a middle finger, he gave an explanation. I accept that in their interpretation of that letter it's a middle finger, but I'm not conceding here in the public court that the President gave the applicants a middle finger. That's not my submission, and it would never be my submission with respect.
Well, my ladies, I accept that. Obviously, the issue about let's put it nicely, the President failed to give us the reasons that we requested for until today. Let's leave it at that. So if I never wanted to convey that my learned friend considered what that means. What that means is our submission. That the failure, as Justice Brand said, the failure to give reasons is basically telling the citizen, go and jump in the lake. Yeah, but that's my submission, not Mr.
Yes, yes, sir.
That's good. Cut.
Okay, we're going to adjourn to consider your argument. We will come back at 2. Yeah.
That's good.
Yeah, at least to get a chance to have your lunch.
Well, indebted to the court, Mr. Manager will be paying.
Okay. So we're going to take an adjournment now until 2 o'clock. Then we'll come back with our ruling at 2. The court adjourns.
All right.